Welcome to this fifth episode of the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and its real world impacts coming from insights from top researchers. Today, we'll travel to the UK to learn a bit about the current trends and the current stance of the British Competition Authority, so the CMA, in regulating digital markets and intervening in them through ex ante regulation. To do that, we have with us today Ronan Scanlan, a partner at Steptoe. And if you're interested in digital regulation, I would really recommend for you to follow Ronan on LinkedIn. And especially, I would also recommend for you to follow his newly released newsletter, The CMA's Critical Friend. And he has worked on the topic of antitrust and also competition in regulated markets for more than 15 years, including his experience in the CMA as a staff attorney, working closely with the European Commission on both merger and conduct investigations. So welcome to this episode, Ronan.
Albert, thanks so much for having me. It's a real pleasure to join you today and to discuss these hot topics.
Yeah, hot indeed, especially because, and some of the audience may already know about the DMA, but now we are experiencing some kind of a shift amongst competition authorities, especially because some competition authorities are also becoming regulators and enforcers of ex ante regulation. So the DMA applies in the sense of an asymmetrical regulation, so it only applies to certain gatekeepers, but it applies en bloc, so that all provisions apply to all gatekeepers. The DMCC is not so radical in its approach, so maybe you could walk us through a couple of the elements that really distinguish or differentiate the DMCC from the DMA.
No, absolutely. And I think it's a really interesting topic for companies, for advisors, for academics to try to unpick, right? Because we've heard a lot about the Digital Markets Act. We've seen the gatekeeper designations in the past 12 months or so. We've seen the initial decisions and even some enforcement decisions earlier this year, fining two companies for non-compliance, Apple and Google. So it's a really hot topic. And I think that the UK equivalent, the UK little cousin of the DMA, the DMCCA, has kind of arrived a bit late to the party, right? So it was supposed to come into force maybe over 2 years ago now. And through delays and legislative wrangling and discussions, it only hit the statute books just at the UK administration with the Conservatives last July, and in fact only came into force this January 2025. It's really kind of hot off the press, and I think all eyes were really on the DMCCA because it had a really ambitious billing, that it was going to go further, faster than the DMA, be a lot more expansive. And the real kind of selling points from the CMA's perspective was, we're not going to be bound by specific kind of codes and approaches in statute. The regime is going to take a more holistic approach. The threshold for intervention and designation, as what the UK refers to as strategic market status, is going to be much lower and more contextual, right? So it's not dependent on that number of 45 million users. It's based on qualitative thresholds. So the first being, does the company have substantial and entrenched market power in a digital activity in the United Kingdom? And then secondly, does it have a position of strategic significance? And we can unpack this a little bit in this discussion, because what this means is pretty amorphous. So this CMA published guidance earlier this year that followed draft guidance last year that they consulted on, and the hope was that it would give a more precise view of exactly what entrenched market power means, what strategic significance means. And in fact, surprise, it didn't really. And these terms are still pretty broad. And that does mean that the potential import and scope and application of the DMCCA as it applies to digital markets regulation is still potentially quite broad. But the idea was the CMA could not just designate the GAFAM, the approach of the EU, but also look at other companies in the UK, or specifically focused on UK business or consumers in the digital services space, and designate them. Now, there is a minimum turnover threshold of £1 billion in the UK, so that does provide one bookend to the universe of potential designees. And then there's also then the requirement around it being UK focused, UK specific towards UK consumers. So I think there was a lot of excitement, I suppose, in the enforcement community when the DMCCA was coming into force. And we have had two initial investigations launched, right? So we've had the SMS investigation to Google in relation to search and search advertising. That has a deadline for the initial decision of 13th of October this year. And then we had Apple and Google investigated in relation to mobile ecosystems. So that's iOS, payment wallets, AI products, app stores. And that deadline is slightly later on the 22nd of October. This is all happening in a very different context to when the act was originally drafted. There's a very different political, economic environment, both domestically and internationally. And it does, I think, have some quite serious implications for how this tool, is used going forward and beyond these two initial, relatively straightforward SMS investigation.
Just to make it clear, because it may be a bit confusing, bearing in mind that we know about these designation decisions. So the designation of Google and Apple by October will mean that they now have to comply with some of the provisions, or are those then added on by the CMA?
This is where there's a divergence between the requirements that are essentially laid down in statute under the Digital Markets Act and what are referred to under the UK equivalent as conduct requirements. And conduct requirements generally relate to things like choice screens, improving choice, encouraging interoperability, ensuring that the companies act on fair and reasonable terms with their suppliers. They're not particularly controversial, the conduct requirements, but they do need to be developed and decided upon on a case-by-case basis. So I think one of the concerns with the CMA had originally been that these elements of each investigation wouldn't run concurrently. So you'd have a decision on SMS by October. Then you'd start looking at, okay, what sort of conduct requirements do we need? And then you'd only get to that maybe the beginning of the following year, and then a final decision in sort of summer 2026. So in a speech a couple of months ago, Sarah Cardell said that her plan was to publish a draft of what the conduct requirements would look like by July of this year. So still while the process is going through to decide an SMS designation. So to try to just double run those two elements a little bit.
I would expect that maybe those conduct requirements would overlap with those that have been present within the market studies and the previous work of the CMA. And I would also explain the delay of the CMA with that previous work that it has really performed to try to get down to the nitty-gritty of what obligations should be imposed, because I also believe that this is quite a fundamental difference with the DMA.
Yes.
There was not so much of a groundwork in the sense of, okay, we are going to identify every single market's failures, so that the DMA is more straightforward, but it is also less flexible in the sense of impacting these digital platforms' business models. And I was also quite surprised in you saying that these designations are going to really bear in mind the UK phenomenon. So maybe what would you expect to happen in terms of designation or conduct requirements that would be different from the European Commission's approach, so that now we already have these 7 gatekeepers? So would you expect any other UK gatekeepers or with having this SMS position to be designated by the CMA?
I might just take those two observations one at a time. So I think you're absolutely right that partly because of the delay in the DMCCA coming into force, if you think of them like transitional cases or legacy cases, CMA had looked very closely at these markets before, and in a sense had looked at them even before the DMCCA was a twinkle in their eye, right? They had carried out detailed market investigations and antitrust investigations into a number of these markets. And so a lot of their work has been done already. And you're absolutely right that a lot of the nature of the conduct requirements have already been signaled in that work. And so, in the example of Google search and advertising, I think it's reasonable to assume that conduct requirements are going to include certain access requirements, requiring Google to give publishers control over how their data is used, including in relation to AI, requiring Google to give access of its data in the context of search advertising to other businesses, giving some degree of protection to publishers, and giving some degree of say to end users in terms of choice screens. And the choice architecture is something quite familiar from the EU perspective as well. The question, I suppose, is, was this billed as evolution? I think it might actually be a much more incremental system than was originally anticipated. So I think the CMA in this new political climate where they have to tread very carefully. There's been a very clear strategic steer from government, both in sort of form and substance. So replacing the chair earlier this year with Doug Gurr, who is an Amazon director of the UK and China, but also in the formal documents around the strategic steer, which was just confirmed last week. The CMA is called upon to focus all of its discretionary efforts, which would include the decision on what SMS investigations to open, towards the government's priorities of growth and investment, and towards the priority areas that the government have identified, which include things like financial services, digital and technologies, creative industries, and defence. So I think the UK has given the CMA a very strong steer that it needs to be pro-growth, pro-investment. I think at the same time, the government has heard a lot of criticism of the CMA and its approaches, which I don't think it would be unreasonable to describe as Byzantine in some respects, both in regard to the procedures themselves and the length and duration and cost of a lot of, for example, their merger investigations, but also the singular focus that the CMA has had when it does exercise discretion and merger control on the focus of AI partnerships. And that, unfortunately, has generated a lot of criticism of the CMA and whether it is focused on the right sectors, the right priorities, and whether it is actually delivering meaningful outcomes for customers, for end users, consumers, and competition. And when you look at speeches by Doug Gurr and by other senior members of the CMA in the last couple of months, they do go back to sort of safe areas. So these are actually sectors where the CMA has already carried out market investigations or antitrust investigations, or indeed have even already applied remedies. And, there was a couple of examples in Doug Gurr's speech to even going back to the open banking remedies and whether they could use the SMS procedure to actually, strengthen those. And, more recently, looking at the commitments around Amazon Buy Box and looking at Facebook Marketplace as well, I think there's a reasonable question there as to whether that would be a candidate that would tick all the boxes from the CMA in terms of an important market, a two-sided market, a market that is relevant both to UK consumers, but also UK businesses, obviously a digital service, and it will also hit the relevant turnover thresholds. So, we as practitioners have spent a lot of time trying to read the tea leaves and try to perceive what would be the next SMS investigation. Will the CMA stop, pause, take stock? Will they focus on the myriad of other powers they already have in market investigations, antitrust investigations, now the beefed up powers under the consumer enforcement powers? Or will they continue to explore ways to identify new SMS candidates? It's an interesting discussion, but of course it creates exactly the opposite of something the CMA is committed to, which is the CMA wants to be more predictable and more proportionate. But at the moment, there's a great deal of uncertainty, and it seems quite unpredictable actually as to where it's going to be going in the next 6 months.
The note on predictability really reminds me of the DMA, because when it entered into force, then the obligations started to apply to those gatekeepers. It was really surprising that the enforcer said everything is clear within the DMA. We know how to apply and to enforce all obligations. Then AI came into the scene, and we do not really know whether AI can be captured via the DMA. But there's also this constraint that if you do not cater to a core platform service, you cannot be impacted by the DMA. I got this reminiscence of the fact that the European Commission's powers in enforcing the DMA were supposed to not be perceived as discretionary, but in fact, when the designations took place, and now that the European Commission has triggered some non-compliance procedures, it seems that such a discretion is more and more relevant, in the fact that on one side, first, it has to prioritize some cases ahead of others, because it cannot handle every single combination of compliance. If you multiply the now 23 core platform services times 22 obligations, you have 500 combinations of compliance. So now you have to decide first whether the provision applies, and then how and whether the gatekeeper's solution really satisfies you or not. Then you have this second tenet of interpreting these flexible concepts that we were talking about earlier with relation to the SMS position. In the case of the DMA with gatekeepers, we have this discussion going on of what is an important gateway for business users to reach end users. And it seems that everything or nearly everything aside from messaging services related to email satisfy the description. And I would really criticize that competition authorities try to maybe obscure their enforcement in saying we are applying the law and this is not discretionary at all. But in fact, there is some scope for enforcement, for their monitoring. And subsequent to that is the fact that courts, and in this case, the General Court and the Court of Justice, must also review the decisions and the choices that it makes. Whereas we have seen that the court's response has not been so clear in that way. And also going back to your points on Amazon buybacks and Facebook Marketplace, these were indeed cases coming from the European Commission. So now I was also wondering how the CMA is really trying to or thinking about reconciling the current compliance solutions that the gatekeepers have already put forward, for instance, with regards to the DMA, because this is also happening. For instance, I was within a panel with the chair of the GFTC last week, Reiko Aoki, and she said maybe with some cases some competition authority must take the lead and then the rest of the enforcers follow. I'm not quite sure whether that would fly with some of the enforcers. So I also wanted to know about how you thought about this interplay between different enforcement powers coming from different jurisdictions.
I normally get accused of asking more than one question, but I think there's quite a lot to unpack there, and they're great questions. So I mean, the first point about AI, I think that's a really interesting crossover because the EU has the AI Act, they'll shortly have the Data Act. The UK has taken a slightly different approach, and we start to see, in terms of follow the leader, less of an enthusiasm for going down the path of heavily regulating AI. Whereas before, I think when we originally discussed the DMA, we started to see a heap of jurisdictions saying, oh, well, we're going to have a digital markets regulation function as well. And, you know, from India to Brazil to South Korea, across the globe, there was a sense of, well, if the EU Commission is doing it, we should be participating as well. And this is important. I think that also applies to online safety rules. But I think that we are at this inflection point. We're at this sort of tipping point where the question is, you know, is more regulation the answer? Is it going to stimulate growth? Is it going to be the right approach when we think about trade talks and international negotiations? Are there ways that actually as a country, whether it's the UK or other EU member states or third countries beyond the EU, is that actually potentially a positive differentiator by turning around and saying, no, we're not going to follow with further regulation? UK, even as lately as last year, said that in these SMS investigations, they would look at markets where AI was particularly prominent and potentially prioritize those interventions. I'm not sure 12 months later that in the political climate that is still the case, but and indeed, I don't know if the UK or EU apparatus is particularly well suited to focus in on AI for AI's sake. And it's clearly a hugely important dimension to a lot of the work that businesses are doing at the moment, and a lot of the interactions that consumers are having with business is now there's some level of AI involvement there. So it's certainly something that's not going to go away in terms of relevance. I think on your second point, in terms of the degree of judicial oversight, there is a differentiator also in the UK. There is a limit in terms of companies that are designated as SMS are subject to conduct requirements as to their legal redress. So they can only appeal decisions on the basis of judicial review. The one exception is penalties, where they can appeal on a full merits basis. But for most of these decisions on SMS and conduct, they have a limited appeal standard. If you have a very broad approach to designation, which isn't based in legal precedent, it's not based on the SLC approach, it's not even really based for conduct on the AEC, the adverse effect of competition approach, which the UK markets regime has imposed for the last 20 years. If you have quite a nebulous approach to designating, and then a very limited appeal standard based on procedural errors, essentially, or unreasonableness, that is kind of quite concerning for business. It's one of the reasons that businesses have been raising about this regime, because the potential for overreach and intervention and the limited capacity for correction if there is overreach is really concerning, because these SMS designations last for 5 years. Then 9 months before the end of that cycle, the CMA decides whether to carry on the designation or not. And you can imagine that having done so much work to designate a firm in the first place, I would think the default is going to be on preserving that SMS designation, because once you have it, it is really easy to impose conduct requirements. It is a little more challenging to impose pro-competitive interventions. And that is the really interesting space for the DMCCA and the differentiator again with the DMA, because a PCI can be anything up to and including full structural divestiture of a business. And again, aligns more closely with some of the processes in the US around breaking up potentially Google, breaking up other companies like Amazon. And that is something that in principle on the statute book at least is open to the UK to do as well via the DMCCA. And then finally, your point about follow the leader, is there a jurisdiction that's best placed? I think that we had a testing period from maybe 2018 to 2024 when the CMA was looking to try to be top table, global policeman. There were various phrases bandied about. I think post Microsoft Activision and that debacle, you can call it lots of different things, but I think the CMA has had to look very seriously at whether it has the resources, it has the expertise, but also it has the political standing internationally to take a divergent approach to the EU, especially on global transactions. Having worked there from 2014 to 2018, I think about it analogously to the way that we approached decision making within the EUMR, within the one-stop shop. I think for mergers that have a particular UK focus or a particular UK nexus, either in totality or just in relation to maybe some plants or factories or specific market that is UK focused, I think the UK and the CMA will feel empowered to continue to, if not lead the investigation if it's an international one, to assert that they have an interest in that transaction. I think it is going to be a more, to say it positively, a more UK focused CMA in the application of these powers than we've seen the last 5 years or so. And that might not be a bad thing. Companies, they have a lot of compliance costs and compliance resource to already focus on the rules under the DMA. Now the DSA, the AI Act and other acts, any sort of comfort that the CMA can provide in guidance or decisional practice, that it is not going to either go against that or conflict that with that, I think would be very helpful.
Bringing all of this into practice, it seems that not only competition authorities and enforcers are playing at this game, it all depends on how wide do gatekeepers want to really expand the reach of their compliance solutions. And it seems that some of them are really welcoming of the fact that, for example, I believe it's with Article 6.9, so with all of the portability tools, they are really expanding their reach onto the UK. But with other gatekeepers and other obligations such as the steering prohibitions or the opening up of alternative distribution on app marketplaces, that these gatekeepers are quite reluctant to accept that the DMA or the DMCC solution might be a golden standard for the rest of the world. So I also wanted to know, what do you expect in terms of compliance strategies coming from the gatekeepers, especially because they can choose on whether to replicate the same regulatory position that they have within other jurisdictions. It does not seem that that's really attractive for them. For instance, Apple, when it contended with the South African Competition Authority within a case, it was asked, do you want to apply the DMA remedies to this particular South African case? And they responded, no, we do not want that, and we want to work out whether South African specific remedies work within the market. Or they can choose really fragmenting the regulatory environment. We are going to apply a different or design or develop a different version of our services throughout the world. For instance, with the Epic Games case, we are already seeing that fragmentation in the sense that we may offer steering for free for developers in the US, that might not be the case for the EU, then Japan also may have something to say. If now the CMA designates Apple with regards to its iOS environment, then it might say we do not accept that it must not be for free. You can derive a profit from that. And bearing in mind all of the current developments and the ongoing efforts that gatekeepers are really directing and trying to combat that narrative of Brussels effect or even a London effect, what would you think that the expectation is for the competition authorities to expect from the gatekeepers in terms of their compliance strategy?
You're absolutely right to call out those specific examples. There's going to be a degree of strategizing both on the side of the enforcement authority and the company as to which is the lighter touch approach, right? So it may well suit Apple in South Africa to look at country-specific remedies there that differ or diverge from their approach in the EU. It's important to remember that companies look at compliance more broadly than just the way we might look at them from a practitioner perspective. So they're also trying to identify strategies that not just work from a business perspective, but work from a GDPR perspective, work from a data management perspective, work from a cybersecurity perspective. There's a whole host of different factors at play. And it may well suit a company to, if it's possible, to take the approach that has been agreed with the EU, the Teams investigation, and the announcement last week around the commitments, the proposed commitments in that case. And I think that Microsoft indicated that if those were accepted, that those would be rolled out globally. And that's quite an interesting proposition to the extent there are benefits for the competitors, the suppliers, the customers with the architecture that they would seek to adopt to satisfy the Commission's concerns in that case. That would be a sort of trickle-down effect broadly, would include the UK, the US, other countries. When it comes to the CMA and the Digital Markets Unit, I think this will also feed into the case selection in the first place, because the CMA needs to actively avoid taking cases that are going to put it at loggerheads with the approach of the European Commission. It would be entirely inconsistent with the strategic steer, which says that the CMA should have due regard to international comity, that should have due regard to whether it is the best placed authority to take action. And if the European Commission is now farther along in its gatekeeper designations, we will now have a situation where the UK is playing follow the leader. And I mean, let's not forget as well, the UK and the EU are signing a cooperation agreement on competition. The technical points have been finalized last year, but this is going to include a mutual notification of potential investigations of mergers. It's not going to include information sharing without waivers, which is helpful. But at the same time, it's clear that it's going to be, if not Reg 1 2003 or the EUMR in law, we're moving back towards that sort of priority principle that we had when the UK was part of the EU. So I think perhaps more than other jurisdictions further afield, like Japan and South Africa and elsewhere, the UK's increasingly de facto position is going to be to align itself. And therefore, when companies consider compliance strategies, there will be a business dimension to it. But I think that they would be well advised to look at their practices in the UK and to seek to align them with the EU. And this might also be a potential shield from future investigations. If the companies that could be designated are already following practices that they've been negotiated and agreed with the European Commission, then why should the CMA open an SMS investigation at all?
I believe we can end the conversation by maybe picking up a point that you raised now around the topic of the principle of international comity, which really ties in with merger control. There have been some tensions between European Commission and the US authorities in what mergers should each competition authority review and the extent to which they can impose remedies with regards to problematic competitive structures that do not really impact the EU or impact the EU in a minor way. For finishing the conversation, I cannot refrain myself from raising the topic of mergers and the renowned phenomenon of the vanishing killer acquisitions and how those are going to be handled within the EU, because now we have this situation where we may have identified some kind of killer acquisitions. There are some that really challenge the fact that those acquisitions may be so harmful for the market, and the European Commission tried to solve that through reinterpreting Article 22, and the Court of Justice said no, you can't do that. So now we have to take recourse to European member states really calling in those mergers and referring them to the European Commission directly. We have seen that with the NVIDIA Run AI case, and now the General Court will have to rule whether that is really admissible or not. So my last question to you would be, how does the UK really think about the problem of killer acquisitions, and whether the DMCC really tackles that potential problem or not, and how do you see it evolving within the EU as well?
No, it's a great way to finish. And you know that merger control is something very close to my heart, because it was quite a big chunk of what I did at the CMA in the mergers unit. And for me, killer acquisitions, I have to confess a little bit of skepticism when you actually put enforcers and some academics to proof exactly what the basis and concern is for killer acquisitions. You often find the evidence base is extremely limited. Certain mergers are referred to that were not investigated or were cleared, and then 10 years later there's a competition problem. As an ex-enforcer, the biggest concern I have is, well, to correct those exceptional cases by ensuring that it will never happen or never happen again. The amount of cases you have to investigate, and potentially the number of non-anti-competitive mergers you would have to prohibit or try to prevent, would completely disproportionate to the potential hypothetical concern. It's a bit like the Scarlet Pimpernel. I see him here, I see him there, I see him everywhere. It's like, but where? And I think when it comes to the CMA and the UK, it is the last jurisdiction that needs more powers. We have had the share of supply test for the last 25 years, which has been applied incredibly broadly, to the extent, if you have a 25% share of supply with some increment, which can be minuscule, CMA can assert jurisdiction, investigate. This is the basis in which they investigated most of the AI partnerships, Anthropic, Microsoft, Inflection, and others. Despite then clearing them or finding that they weren't mergers at all, they apply this share of supply. And what is a metric you can use? You can say, well, 25% of the basis of patents filed in the last 6 months, or the number of employees you have compared to someone else, or it is so broad, it has no bearing on market definition, no bearing on conventional approaches to calculation of share. It's already something, in fact, that the UK government is looking to curtail. It's one of the specific areas that the government have said we're going to legislate for greater certainty in the application of share supply. Now, the DMCCA brings in a further hybrid merger test. So if the acquirer has 350 million, they can call in a transaction regardless of the level of share of supply, or even if there's no increment to the share of supply at all, because of an underlying concern, potentially, say, with leveraging in an unrelated market. And there's also a rule now that any SMS designated firm will have to notify, or at least make the CMA aware of a merger if the consideration is above £25 million, which is what you'll appreciate in tech is pretty much every merger under the sun. So I don't think there's any call for greater powers in this area. I think there is a call for better empirical research and data and understanding of exactly what the problem is. The same reports that are quoted as a reason to expand the call-in powers, like Lear and Furman, are also the same reports that gave us the DMCCA. This idea that the existing antitrust tools were too slow and too cumbersome and too hard, basically, for the authorities to articulate potential concerns, that why don't we just run to the end and give our authority the power to intervene without a legal threshold having to be passed? And that is pretty much what we have with the DMCCA in the UK. Now, thankfully, because of the political realities, because of the minimum turnover threshold, it seems, at least in the short term, that the use of this power is going to be limited. But you have to ask whether, if you are seeking a proportionate and appropriate regime, it is right to have such a broad power on the books at all. And really whether what the companies need is greater certainty, whether that is mandatory filing thresholds for mergers that actually make sense and align with other countries, or potentially a return to what the CMA had before in digital markets. They already had the market investigation regime, power that again put them above pretty much any country in the world. The European Commission is talking about the new competition tool. UK already had it since 2002, So I think that the logic of this additional regime, which essentially takes away a legal enforcement intervention threshold and says if a company is important, have at it, impose conduct requirements, is really another example of going too far in terms of trying to anticipate and prevent these often hypothetical concerns in the tech space, including around killer acquisitions.
So with that note on the need for empirical research, we're going to end this discussion here. Thank you so much, Ronan, for the discussion. We are now going to wrap up the episode. And if you have any thoughts or any feedback for any one of us, so Ronan or me, you can also drop a comment to us below.